Good morning, sir. You're Dan Church.
Oh, yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm. And the state has filed a motion asking that I'm looking at the state's motion. The motion it says aggravated assault.
The prosecutor apologizes for the clerical mistake and explains that the error happened while quickly filing the motion after receiving a sworn affidavit from the complainant. The state tells the court that the complainant, Jeremy Shelton, chose not to appear in person because he fears escalating tensions with his neighbor. Instead, he submitted an affidavit describing his concerns for his family's safety.
That error, obviously, the court would see the probable cause affidavit is very similar to an aggravated assault, discharging a weapon somewhat in the direction of the complainant. In this case, I have had multiple conversations with Jeremy Shelton, the complainant. He is the across the street neighbor of Mr. Church. He is a very nice young man. He was very forthright, came in and presented me or had an affidavit authored by himself with one of my investigators in lieu of coming to docket today. He, as the court can probably surmise, is of the mind that he doesn't want to aggravate the situation. No, not intending to use that same word, but I will tender that as State's Exhibit number 1 just for purposes of this hearing, and I have Mr. Gertz, it's his affidavit just expressing concern about the nature of this offense and the fact that they reside across the street from one another, that he has a very young son and a wife who were also present at the time of this offense, and he has concern that Mr. Church may be keeping weapons at his sister's house down the street. I have worked very closely with my investigator, Mr. Bays, and he is familiar with Mr. Church as well as Port Arthur Police Department is. And we've asked that some things be implemented in the interim time period to hopefully assure the safety of all the parties, including Mr. Church. But I just wanted to bring this matter to the court's attention with that motion. It's not necessarily intended to increase as much as it is to modify with the admonishment regarding weapons, etc., because obviously it's difficult to remove these two individuals from one another approximately because of where they both reside.
Any objection to me reviewing that?
Well, Judge, the rules of evidence don't apply in a bond hearing, so I would love to have some great evidence, but I don't have a good one.
And I'll state the ones admitted for purposes of this hearing. Give me just a second, please.
The defense argues that the existing $20,000 bond is appropriate and points out that Mr. Church has hired legal counsel, appeared in court, complied with every bond condition, and has not contacted or threatened the complainant since his arrest. While recognizing the complainant's fears, the defense maintains there is no evidence that the defendant has violated any court orders and argues that raising the bond would not solve the situation.
Right. I'm not sure what else what else the court could impose because of the proximity of their homes without infringing on his constitutional property rights of his own. But I think the fact that he's hired counsel has shown up to court he's taken this seriously. He's not been threatening the complainant or anything of that nature. I understand the complainant may have concerns, but those are the complainant's concerns. They're not being triggered by anything, no pun intended, by anything that Mr. Church has done since his arrest or his indictment. And so, and he's not violated any of his bond conditions that
I think
that I'm aware of.
Is if they feel like he is watching, could be, just uncomfortable. There's an allegation that he's sitting in his car watching family, obviously based on the nature of the offense and the allegations and the probable cause, that would give me some concern too if I lived across the street and that had actually happened. So,
but I just don't think raising his bond and discharging him more is the proper remedy for that. So I'm not sure how the court remedies that. And I don't see
the way it gets remedied, Mr. Church, is if you're doing anything that's making the person uncomfortable, that's the complaining witness in this case, the only way for me to take care of that is to put you in jail. Then they don't have to, nobody has to worry. I don't want to do that, but I need you to understand that there's no way around if, you're not contacting them or talking to them. I get that. But if you're doing other things, like sitting in your car and watching them, then that's going to be of concern to me. So I'm ordering you, here's what I'm ordering right now. Listen to what I'm going to say very clearly, okay? This no contact order is going to include literally looking that direction. You can't sit on your front porch. You need to sit in the back. You can't just sit in your car for no good reason. People don't do that. So you're not going to do that. Do you understand? So if they feel uncomfortable, they're going to let Ms. Malfino know, and you're going to end up in jail. So I understand you live across the street, but if I were you, I'd walk. If I was going out my front door, get in your car and leave if you're going somewhere. No lingering, no looking that direction, no standing there watching. Otherwise, you're going to end up in jail because I won't have any other choice. Does that make sense? Okay. So we'll reset this for an announcement. Make sure you stay in touch with Mr. Gertz, visit with him before that next court date, and we'll see if we can get an announcement, okay? You're free to go.
Thank you.
Oh, here. One of those is just what I printed out. Do you want the exhibit or does that go in the file? Thank you. Which one is it? Which one is it? Do you know his name? Sleepyhead, John Gray?
John Gray.
John Gray? John Gray?
John Gray. John Gray.
Good morning. You all right, Mr. Gray?
I can't have a thought.
You okay this morning? Why are you sleeping?
Work.
Work. Have a seat in the jury box. I'm going to get you tested this morning to see if there's anything in your system.
I see him back there.
Do you understand?
Yes, ma'am.
Okay, go back with the bailiff.
Speak freely, maybe.
It's probably not a good idea. Go back with the bailiff.
Right now. So,
Come my wife.
I give them.